Welcome everybody. Really brief introduction. My name is Rob Nuddleman. Don't hold it against me, but I am an attorney. I practice employment law. I'm not here to sell you on any employment law stuff. I thought we were going to talk about Amway today, but apparently instead they want me to talk about hiring and working with caregivers. I work with a lot of families that hire caregivers. Many people hiring them to come into the home. Some in facilities such as here. I work with families, fiduciaries, attorneys, and other people kind of in the circle of care. And there are some do's and don'ts. And what I'm hoping to do, and I'm really trying to get the word out to educate as many people about some things that you can do, can't do, shouldn't do whenever you're hiring a caregiver. And that applies if you're hiring a caregiver through an agency or thinking about hiring them directly, because there are some very easy mistakes to make that can actually be pretty costly. And so I get a lot of clients who call me after they've hired a caregiver and maybe they've not done things the way they should have, and all of a sudden they get some letter from an attorney saying, hey, you did something wrong. And it can get pretty expensive to fix that, whereas if we just did things from the beginning, it'd be much easier. So that's really my goal. If you guys have questions at any time, certainly about employment law or caregivers, let me know. I will do my best to answer any questions you have. Just jump in anytime. So kind of the first question is, who is an employer and why is it important? Many people don't ask that question when they're hiring a caregiver because they figure, hey, this person says they want to do some work for me. I'm willing to bring them in to do the work. Then we're adults. We can make those adult decisions. And that's true, but the law does create, or says that actually creates an employer-employee relationship. How many people have ever been employed before, had an employer, or had employees? You know, so we've all gotten a paycheck, and there's these rules and these laws that if we don't follow them, well, we get into problems. So kind of there's a big old history jumping a way back machine. There was these specific tests to determine who was an employee and who wasn't. And it looked at level of control and can somebody be an independent contractor and when they can't. Well, in 2014, the law changed significantly when it comes to caregivers. Now, first of all, I will tell you, it is almost impossible to hire a caregiver as an independent contractor. It is almost impossible to hire a caregiver as an independent contractor. The law just doesn't see the relationship that way. And it's because of how they define what is or is not an employer. And that was the standard. Back when I started helping families hiring caregivers back in 2008, people were hired as independent contractors. They were paid under the table. They were paid a flat amount. Get paid per week or per shift. And it kind of went unnoticed for a long time. And then the unions really pushed to get some laws passed for the protection of caregivers, because there was a lot of caregivers who couldn't leave the house because they were bound to take care of somebody, or they weren't getting paid correctly. And so in 2014, they created what's called the Domestic Workers' Bill of Rights. And under that Domestic Workers' Bill of Rights, they broadly described who is an employer. And it includes, for when you're hiring a caregiver, it's anyone who engages someone to work. So if you hire them, or if you control the hours, wages, or working conditions, or in some circumstances, if you just suffer or permit somebody to work. So let's think about that. If that means if I hire you to be my companion, just, hey, make sure if I fall, somebody's going to be there to call 911. Or maybe I need some help with daily reminders on my medications, or I need somebody who's going to help me, whether it's anything from toileting or just being my companion. If I am deciding how much I'm going to pay that person, or deciding what type of services I want them to do, I am controlling their wages. I'm controlling their working conditions. I'm controlling their hours. So under the law, that makes them a domestic work employee and makes me a domestic work employer. There's a couple of different words that we're going to be using a little bit. So first of all, this all falls under what we call household workers. Household workers are people who are employed to work within the household. So even if you reside here, this is your household, right? So if you hire somebody to come in, it could apply as a household worker. There's actually slightly different rules that apply to an assisted living facility. I'm going to try not to bore you too much with all the legalese, but you can have specific rules that are the more stringent rules that apply when you bring a worker in to this type of a setting versus if it was your own independent dwelling outside of a facility. When I say caregiver, I'm typically referring to what the law calls a personal attendant. A personal attendant is someone whose primary job is to dress, feed, or supervise somebody who, as a result of age or disability or medical condition, needs a little bit of extra help. That doesn't mean they have to spoon feed you. They may be helping with preparing meals. They may be helping with cleaning up. They may be helping with those, you may have heard, activities of daily living. And that's their primary job. It wouldn't be necessarily a chauffeur, even though they might occasionally drive you somewhere. It's not really a cook, even though they may occasionally do some cooking and helping out. Slightly different, the federal law talks about a companion. Companion is similar, but it really is focused on somebody who's just there to provide companionship and fellowship. Somebody's there to keep you company and, hey, if there's an emergency, help me up, or call 911 if necessary. We don't have to worry too much about those distinctions because in the most part, they're somewhat synonymous, a companion and a personal attendant, but there are slightly different rules. I mentioned that there are slightly different rules in a facility such as this versus somebody in a household. So typically, I'm going to put it this way. There's all sorts of laws. There's this thing called the labor code. That's our basic laws when it comes to employees and employers. But every single place of business also has a wage order that applies. And it's a series of regulations. There's like 17 different ones. There's one for construction industry, one for office work, one for agricultural workers. And there's one for household employees, people who are employed by the household owner. There's a separate one for people who are hired in a place that provides room and board. So such as an assisted living facility that provides room and board, wage order 5 applies. Why does it matter? Well, because different wage orders say when the employee is entitled to pay at different rates, overtime. When you think about it in a normal job, if I work more than 8 hours in a day, my employer has to pay me time and a half. If I work over 12 hours in a day, they have to pay me double time. Well, there are some special rules when it comes to caregivers working in a household. And I will also tell you that some of these rules are not really well defined yet. There's laws, but then there is how is the court going to interpret it? And there's some ambiguity. So I always try to recommend what makes sense, but also what is going to be riskier versus not risky. And then we also have to worry about certain cities and counties. So we're in Redwood City right now. I believe Redwood City has its own paid sick leave law. I'm not positive. But if you go to places like San Francisco or Emeryville, Los Angeles, Oakland, Berkeley, San Jose, they all have higher minimum wages. Does anybody know what minimum wage is in California right now? What do you think about? 15. Close, 50. It's $16.50 in California. Federal law is like $7.25. And the whole idea behind minimum wage is, well, when minimum wage at the federal level was created back as part of the New Deal, it only applied to people employed by the federal government. And the idea was a single wage earner earning federal minimum wage working 50 hours a week, 40 regular hours and 10 overtime hours, could support a family of 3. So just put that in, could you earn $7.25 and support any family, let alone a family of 3, particularly not here in California. But California has a higher minimum wage. It's $16.50 an hour. Certain cities like San Francisco, it's closer to $20 an hour. I think Hollywood right now takes the highest. It's at 21 or something. I always have to look it up. It's written down. And then there's different rules that can apply depending on where the work is being performed. Again, I told you my goal is to kind of give you some information that you need on things to do and don't do. My number one rule is paying people correctly. A very common story that I hear. A family member comes to me. We have a caregiver. They're great. They've been working out really well. But now we fired them for one reason or another. Maybe mom, dad passed, or we no longer need care. And all of a sudden, this person is saying they were owed wages that we didn't pay. And we don't, is that true? Do we really owe that? And so I start asking some questions. Very frequently, I'll say, well, how did you pay the person? What was their pay arrangement? Well, we would pay them $300 a day, or $500 a day, $600 a day, which if you're going to go through an agency, that's expensive, but that's not outrageous. And I'll explain why in a little bit. Because they're paying the caregiver on a daily rate, there's this really unique thing about California law. California law says that a salary does not pay the employee for all hours worked. It only pays them for the non-overtime hours. And we're going to talk about how that looks. So if I can impart the most important rule I would say, if ever you decide to hire a caregiver, whether it's a caregiver outside of the facility or a caregiver to come in here and you're going to pay them, do not pay a daily rate. Do not pay a salary rate. Don't do a shift rate. Always, always, always pay by the hour. If you pay by the hour, regardless of anything else you do, you will have saved yourself a lot of trouble and a lot of problems. Because the way that the law works, saying that the salary only compensates them for non-overtime hours, that means if they worked overtime, you have paid them nothing for those overtime hours. And the way you decide how much they should be paid gets very expensive very quickly. So number one rule, always, always, always pay by the hour. Don't pay a daily rate. Don't pay a weekly rate. Don't pay a shift rate. Even if they say, oh, don't worry, you just pay me $300 a day, break it down into an hourly rate. Okay, hey, I need you for 5 hours a day. You want me to pay you $300 an hour? I'm not good at math. I went to law school, so I didn't have to. Whatever that equals out to be, 15 bucks an hour, 20 bucks an hour, whatever it is, I'm going to pay you $20 an hour. Have them tell you how many hours they worked each day, and you pay them based on the hour. If they worked 5.5 hours, pay them for 5.5 hours. If they worked 4.5 hours, pay them for 4.5 hours. You can pay different rates for different work. You don't see it too much in a facility such as this, but I see that at home where, hey, wait a minute, I don't mind paying $20 or $25 an hour when you're helping me, but there's a lot of time, like when I'm sleeping, I don't want to have to pay you that kind of money. I mean, I want somebody there just in case there's an emergency, but I don't want to pay you if you're sleeping. Well, the law says if I require you to be there, even if you're sleeping, I have to pay you for that because you're under my control. But I could say, I'm going to pay you $25 an hour for when you're actively doing stuff. But when you don't have any duties, you don't have to do anything, you just have to be here, I'm going to pay a lower rate. As long as you never go below that minimum wage. So right now, that's $16.50 for state minimum wage. For caregivers in a household, they get overtime if they work more than 9 hours in a day or more than 45 hours in a week. So that means if I hire somebody for a 24-hour shift, let's say I want to live in, that means I'm paying them for 9 regular hours and 15 overtime hours every single day. When you do the math, it gets expensive very quickly. Now, when you go through an agency, if you have to have an agency that you want to use, which I will tell you, I almost always recommend go through an agency if you can. There's good things and bad things about them. The good thing is they're the employer. They're the ones responsible for making sure people get paid correctly. The rules are a little bit different for them. They actually have to pay overtime after 9 hours in a day and 40 hours in a week. That's in a house, like in somebody's apartment. In a facility, we have to follow these other rules, the wage order 5 rules, which means they get overtime after 8 hours in a day, and they get double time after 12 hours. So it gets very expensive. So that same employee working a 24-hour shift will get 8 regular hours, 4 overtime hours, and 12 double time hours. It gets very expensive very quickly to have a single caregiver. Now, usually in a facility, you don't need somebody 24/7 because that's one of the benefits of being in a facility is they do have some care that provides you that you don't need to have necessarily an attendant 24/7. The other thing is, cool question.
Sorry, I think just for distinction for everyone, you hear us, we say companion. If someone's not an Oakmont caregiver, they are a companion, right? And we do use that purposefully because, as you know, only Oakmont caregivers can provide care with the ADLs and that. So I just want to throw out that distinction just because it may get confusing. But wait, what do you mean caregivers? We only do companions.
And most residential facilities are very similar, assisted living facilities, where you come here and you are paying not only for a nice place to live and good food, I'm told the food is good, right? Okay. But also they are helping with those activities of daily living. And that's the type of caregivers they're providing. Now, you may still want to have your own separate companion because as good as Oakmont may be, they can't be everywhere all the time. So some people want that additional extra care. So when you do bring them in, whether you call them a companion or a personal attendant, it's a great way to distinguish by using that word caregiver. We really would be talking primarily of a companion, somebody who's really providing some protection and fellowship. Nonetheless, because it's in a facility, you may be stuck with the rules that are going to come out where you have to pay overtime after 8 hours in a day. Again, typically we don't see it in a facility, but outside of a facility, we may have 24/7 or live-in care, and people say, well, wait a minute, this person's getting free rent. We're in Redwood City. It's an expensive place to live. Renting out a room could easily be $1,500 a month or more. Don't I get to deduct that? No, you don't. You can deduct some, but the maximum deduction for if you give them a room is about a little over $75 per week. It's nowhere near what market value is. So be aware, and if you're going to do any kind of deductions, it does have to be in writing. So people think that, I'm giving them free room and board. Isn't that part of their compensation? Yes and no. You actually don't want it to be part of their compensation because then everybody has to pay taxes on that separately. And that goes into the reasonable value of that goes into what their regular rate of pay is. So I typically don't recommend trying to do those deductions. The other issues you have, particularly with live-ins, is sometimes they'll say, well, I can't deduct your wages or this room and board from your wages. So why don't I just have a rental agreement? And that is a perfectly acceptable. You can rent it out to them at fair market value, particularly if you don't really need 24/7 care. You just want care during the day. Downside of that is, remember, you're paying an employee. They're paying taxes on the wages they're getting. You're paying taxes on the wages you're paying. And now you're also going to pay taxes on the rental income. Huge caveat. Never, ever take my tax advice. I've literally screwed up TurboTax twice. My wife doesn't let me go near it. My CPA just asks me questions. They take care of it. But if you have tax questions, go talk to someone. So keep in mind, I mentioned about overtime could be creating, if you're giving them rent, that could increase their regular rate of pay for overtime. And then you could also be creating an unintentional tenant. And it's not always easy to get a tenant out of your home. So that's the other consideration if you want to go 24/7 live-in. I'm not a big fan of a 24-hour-a-day, 7-day-a-week live-in caregiver in somebody's home. I think it's a lot of risk for potential elder abuse issues. I think that there's risk for malfeasance. It's very expensive, and you run into all these other problems. We talked a little bit about, if you require somebody to be there, you have to pay them. That includes sleep time. Used to be common that because there are rules under the federal law that say if somebody works a 24-hour shift, as long as you give them at least 5 hours of uninterrupted sleep time, then you don't have to pay them for that. In fact, if they're not interrupted for 8 hours, you don't have to pay them for up to 8 hours. And we thought we could do that. Well, no. And about 2016, California Supreme Court said, no, that's federal law. We're more strict in California. So if you require them to be there, even if they're doing nothing, you are required to pay them for that. So even if they're reading books, they're watching the internet, they're watching TV, they're sleeping, if you require them to be there, then you have to pay them. So one thing some families do is say, well, look, I don't really need you from midnight to 6 a.m., so you're free to leave at that point in time. With the belief that that means, who's going to really leave at midnight, right? I mean, you have a nice warm bed, you could stay here. You've got to be cautious about that, because that kind of little wink and nod situation of, hey, I don't really need you here, doesn't apply, or you can't really use that, particularly not if there are, say, medical records that say you need 24/7 care, or we recommend 24/7 care, or if you're getting up frequently in the middle of the night. So those are things you can do, but there are certain cautions on those. If you're going to be hiring somebody to come in as a companion, whether it's in this facility or otherwise, you are an employer. That means you have to keep certain records. We already talked about you want them to tell you how many hours they're working. We need to keep that record. You're supposed to keep that record for at least 4 years after they stop working. Now, I don't care what that record looks like. It could be text messages, email messages, written on a notepad, done into an app, done on timesheets, time clocks. It doesn't matter, as long as we have what time did they start and what time did they stop. That's all that really matters. Technically, you could get away with they worked 6 hours or 5 hours, but I prefer I showed up at 10 o'clock, I left at 12 o'clock. Now, some people might be tempted. We're in Oakmont. Edward, Oakmont, when people come in, they sign in, visitors. So one might be tempted, wait a minute, why do I have to keep track? Oakmont already has a sign-in sheet. No, you can't rely on Oakmont, because that's their documents. And it also has information of people other than whomever you might hire. So while that might be good for some purposes, I would not rely on that as the record of hours worked. You also want to keep a record of what you're paying. It is perfectly legal to pay in cash. I don't advise it. And if you're going to do it, you better get a receipt, because if you don't have a receipt, there's nothing that stops the caregiver from later saying, pay me, you didn't pay me, I didn't get paid anything. I told you what I was working, I'm still waiting to get paid. It happens. If it didn't happen, I would be out of a job. So keep a record of what's getting paid. It can just be the check stub. Yeah.
If the family hires the companion through an agency, then the agency will take care of all the records.
Yes. Yes, and thank you. So the question is, if the family hires through an agency, that means the agency does on that. Absolutely. And that's one of the reasons I like using an agency. Agencies, you're going to pay a little bit more than if you paid privately. And the consistency on the caregiver may not be the same, but there are so many more benefits to using an agency that I like. One, they're the employer. They're keeping track of the hours worked. They're negotiating the pay rate. They're able to provide vacation and health benefits that will attract and retain people. They provide training, all those things that employers are required to do. And also, what happens when the caregiver is sick? If I hire a companion myself, and it's just a one-on-one contract, and that person is sick, well, what happens if I still needed somebody to accompany me to go on a walk to the park, or go to the doctor, or some other type of activity? Well, now I don't have somebody. If I'm going through an agency, then they're going to be responsible for ensuring somebody's going to be there. So that's always my first recommendation. Now, I would not go through just any agency. I would use a reputable agency. I'm defending a case right now where my client hired an agency, paid an extremely low amount for a caregiver, and the agency did not pay the caregiver correctly. And now, after having hired that agency for a year, paying that agency probably around $100,000, is now going to have to pay an additional $200,000 to the caregiver because the caregiver didn't get paid correctly, and the agency doesn't have any money. So use your referral sources. Oakmont probably has recommendations of places. Talk to other people. Look at Yelp reviews. I would err on the side of using a bigger agency that's more well-established versus one that's smaller. And there are 3 questions I would recommend you ask every single agency. Number 1, do you use employees or independent contractors? If they say they use independent contractors, walk away. Remember, I told you, caregivers rarely, if ever, can be independent contractors. So assuming they say employees, next question, very simple. Do you follow all federal, state, and local laws? If they say no, walk away. They're going to say yes. Which just leads us to the next question. Great, will you put that in writing? A reputable agency will not have a problem saying, we are the employer. In fact, they want to be sure they're the employer, and we follow all state, local, and federal laws. Having that in there gives you kind of an extra layer of protection. So ask those questions. I kind of jumped ahead of myself. As far as what records, primary hours worked, and wages paid. If there are any expenses, like maybe you have the companion, hey, can you run to Walgreens and pick up my prescription for me? Or, hey, Oakmont's food's great, but I really want a Ruth's Chris. I want a steak. I want a big steak. Go out and buy me a steak. And they go out and buy you a big steak and bring that in. Well, if they're driving their vehicle, you have to pay them for that, if they're incurring expenses. So just keep a record of those expenses that you paid. And then if there are any personnel records, if you're going to hire somebody, again, if you go through an agency, all this is taken care of for you. But if you're going to hire directly, there should be some sort of an agreement, something in writing that says, I'm hiring you to do this. These are the hours I want you to be here. This is how much I'm going to pay you. Those are your personnel records that we want to make sure we maintain. So what are our simplest solutions? Well, we talked about using a reputable agency. Those are care agencies. There's also something called a referral agency. A referral agency is different than a care agency. A care agency, they hire the workers, they are the employer, they actually are responsible for assigning who's going to show up when. A referral agency connects you with a caregiver. I'm not a fan of referral agencies because all they're doing is making a connection. They might do some background checks, but they are not the employer. And I don't think they do a good job of explaining they're not the employer. They leave it up to you to decide, okay, how am I going to hire this person? And then you're going to continue to pay that referral agency for the life of that contract, even though they're not doing anything for you. I would much rather see you use a reputable agency than a referral agency. There are also things called third-party employers, where they are the employer of record. You're still the one doing the hiring. You're choosing, this is the caregiver I want. There's really only one third-party employer I'm aware of that does caregivers. There's other ones you may have heard of, things like TriNet or Insperity. Those are large employers. Workday, where they hire people and they kind of place them in other places. It's kind of like that. The only one I know of that in the caregiving industry is a company called Team Risk Management down in Southern California. And they typically only work with banks, or if you have like a private professional fiduciary conservator trustee. So they're not much of an option, and they usually don't come into situations here. The other thing you can do, know and comply with the law. Well, I do not expect any of you to go out there and start practicing employment law and understanding these things. So at the very least, establish a relationship with somebody who knows what they're doing. So before you hire somebody, call a knowledgeable person. Talk to people. How do they do it? What are the ways to do it? The internet is great, and the internet is terrible. You can get a lot of information off of it. Some of it is accurate. A lot of it's not. But it's a good place to start. Websites that you can trust, government websites. You know, if you're looking at an attorney's blog, it may be helpful. I write articles all the time, but you don't know if what I'm saying is accurate or true. So if you're going to do your own research, default to government websites. It is much less expensive to talk with somebody ahead of time, pay somebody to get some advice ahead of time, than it is to find out you did things wrong a year or 2 or 3 down the road. If you're a family member and you're hiring for your parent, a companion's going to be hired for your parents. Remember the beginning I was talking about who is an employer? If you control the hours, wages, or working conditions. So when I interview a companion and say, hey, I want you to help take care of my mom or dad, this is what we're going to pay you, this is what we're going to do, I am becoming the employer. As is my dad or my mom, because mom and dad are going to be telling them what to do. Sometimes I'm going to be acting in the capacity of, say, I'm a power of attorney for my parents, or a trustee of a trust, or a conservator of a person. I want to make sure if I'm signing any kind of contracts, I am signing in that capacity to make it clear that, no, I'm not doing this as Rob Nuddleman. I'm doing this as the power of attorney for my parents. So just identify your capacity when you're doing that. I mentioned about written agreements having something in writing. It doesn't have to be overly fancy. It can be written on the back of a napkin for all I care. I do want it to be something that both parties sign, and it should have some basic information. Keep in mind that if it's not in writing, it doesn't exist. Or actually, I think more importantly, if it would help you but hurt them, it doesn't exist. Keep in mind, people come to me when they have problems. So a lot of my perspective is fixing things after there's been a problem. There are a lot of great, wonderful caregivers out there that are not out there just to take your money. I have a habit, or not a habit, it's my business to help people that, problems have arisen. So I try to figure out what do we do now to ensure there's not going to be a problem. So what are the terms that we want to have in there? Well, who is the employer, right? Is it going to be mom? Is it going to be dad? Is it going to be one of the children? If you're hiring somebody directly, put that in there. What is your capacity? How much am I going to pay? What am I going to provide any benefits? Most of the time, you're not required to provide health benefits unless you have 50 or more people that you're hiring, so we're not having to worry about that. But there are certain things like paid sick leave that you have to provide. And I always like to have language about this as at-will employment. The employment relationship can end at any point in time. There's always an issue about workplace injuries. And one of the nice things, like here at Oakmont, all of their workers are covered by what's called workers' compensation insurance. If you were ever employed or if you ever had employees, workers' compensation policy was in place. And that means if I slip and fall when I'm doing my job, or I hurt my back, or I cut off my hand while I'm working, then there's going to be insurance that's going to cover that. Well, when you're hiring directly, you have to make sure you have workers' compensation insurance. If you're bringing in a companion on your own, I don't think Oakmont's insurance is going to cover that. So that means you have to get your own insurance. Now, if you were in your own house and you have homeowners insurance, you can get a rider and you can get workers' comp built into that a little bit more easily. It's a little bit more difficult in a facility. Again, if you're going through a care agency, they're taking care of the workers' compensation. You don't have to worry about that. If you're renting a place as opposed to, and I don't know exactly how Oakmont is set. There are some facilities where you are renting, they have various levels. Lowest level, you're renting a place and you can come eat here if you want. Next level up, okay, well, we're going to manage all your meals and we're going to provide assistance with activities of daily living. All the way up through memory care and locked facilities and things like that. And I'm not sure what level or all levels Oakmont does. If you were at a level where I'm just renting a space and I get to eat here, you might be able to have renter's insurance that could cover that workers' compensation insurance, but you'd want to talk with your insurance carrier to be sure. I mentioned that a lot of times people come to me once there are problems. And there are ways to resolve things. It is a little bit more difficult. If you follow that one, really, what was that big rule I said? The number one rule. Pay hourly. If you pay hourly, you will avoid most of the problems. But sometimes, maybe we didn't do that correctly, or maybe we paid hourly and we didn't pay everything correctly. Maybe it's we want to fire this person and we're concerned about how to do that. what I first want to tell you, like, when is the right time to resolve it? If you think there's an issue, that's a good time to seek help and talk to somebody who's knowledgeable to find out. If you get a letter from a law firm demanding something, or if you get a letter from the government demanding something, that's something that needs to be addressed. It shouldn't, don't just file that away and hope it's going to go away, because it's not. If your companion is doing things in a way that you don't like, address it with them. I mean, that's the time to have that conversation with them. Waiting for a year to say anything while you've been putting up with somebody's behavior is not the best way to do it. If somebody at Oakmont, they say, is not treating you the way you want to be treated, have the conversation with Oakmont so they can address it at the time, as opposed to waiting for a long time to go by. So when is the best time to resolve it? As soon as you think that there's a problem, that's the best time to address it and look at how can we do it. Oftentimes it comes to me, it's like, oh my gosh, we may owe this person some money because we didn't pay them correctly. How do we go about paying that? Well, there are times when you can have somebody sign a piece of paper that says they're not going to sue you. In order to have that be valid, you actually have to give them something that they're not already entitled to. So if I owe you $500 and I say to you, you know what, I'm going to give you your $500, but before I do, you have to sign this paper saying you're not going to sue me. That is not a valid release, because I already owe you the $500. I'm not giving you anything you're not owed. Now, if I say, yes, I owe you $500, but I will give you $501 if you sign the release. Well, now that release might be valid. Or if you say, hey, Rob, you owe me $500. And I say, no, I don't think I owe you $500. I think I owe you $300. I'll pay you $500, but I don't think I owe you all that. Well, now there's a dispute, and that release may be valid. So there are different ways to have the conversation, have the negotiations. And we can't make it up and say, no, I really don't owe you anything, when you really know that you do. But there are times when that release can be valid and times when it's not. Yeah.
Wouldn't it be easier to have them sign a release before you engage and commit to any money?
The question is, can't I give them a release ahead of time before you engage them? No. A release is only effective to waive claims that happened in the past. Any of you have ever been on an amusement ride, or you've put in a lottery, and you parked your car in the garage, and you get the little thing that says, we're not responsible for anything that happens to your car. Those are of very limited value. Those aren't an actually effective release. If you park your car somewhere and it says, well, we're not responsible if your car gets damaged, and then one of their workers comes by with a sledgehammer and breaks your car, they're still going to be responsible. What that does is it creates hey, just so you know, there's a risk. There's a lot of cars in here. Somebody might bang up your car. It's not our fault. It can limit the liability, or it can reduce the liability a little bit, but it's not going to eliminate it. You can only really eliminate liability by having a valid agreement where the parties are agreeing, I'm going to give you this, you're going to give me that. Now, we could agree, look, I'm not going to sue you, you're not going to sue me. That's valid. We're exchanging something. I would not recommend trying to do a release agreement on your own. Again, it's one of those, ounce of prevention is worth a pound of cure. It's a simple thing to do, but it's also an easy thing to do incorrectly. And what I don't want you to do is pay money to somebody thinking, oh, this is going to have them go away. This is going to resolve everything, when it really doesn't. So that's kind of like a really quick and dirty version of everything, hopefully, that you need to know and some of the risks. High-level things, if you're going to hire a companion directly, have it in writing and pay an hourly rate. Preferably, go through an agency. Go through a reputable agency where they're going to be the employer. Be aware of, the facility where you're living in may have rules about what what your companion can do and cannot do. And a lot of that is for liability reasons. I'm presuming Oakmont knows the people they hire. They've trained their employees to work a particular way, how to lift, how to carry, what medications to give, what medications not to give. When you start inserting other people that are taking over some of those duties, it creates a liability issue for Oakmont. And so for your protection, as well as Oakmont or whatever facility you are, they may say, look, you can have people, but they're not to provide these things. You can only have like a companion level.